Вітаємо вас, пані Світлано.
Welcome, Svitlana. Good afternoon. I'm happy to see you.
І ми вас також.
We are happy to see you
На
too.
другому етапі конкурсного добору.
Welcome to stage 2 of the selection for HQCJ, stage of the interviews.
Бесіда з вами проводиться
Your interview will be conducted by all members of the Commission. Let me introduce them briefly. It's Yevhen Mezentsev, me, Ivan Mishchenko, Tadza Zhachny, Robert Bergeisen, Steven Markman, and Sergei Verlanov.
Доповідачами на вашому інтерв'ю.
The rapporteurs for your interview are Tadza Zhachny and me.
Якщо з якихось причин
Thank you. Should for any reason your interview be interrupted, we will resume it on a different day and at a different time, and we will reach you before doing that. We're kindly asking you to be brief and precise when answering our questions, and a commissioner asking you their question has the right to limit the time for your answer. Before we start the interview itself, you will be given the floor for self-introduction, and you will be able to tell us and also tell the audience about your motivation, your ideas about the new HQCJ and the judiciary in general. Welcome. And I'm passing the floor to my colleague, the rapporteur, who is Tadza Zhachny.
Yes, good afternoon, Ms. Kustova. Ms. Kustova, we, in these interviews, provide a little bit of an introduction to the candidates, and that is for other candidates and other viewers that are joining this live streamed interview. So I will begin my introduction by reporting that you were born in 1971 in the Dnipropetrovsk region of Ukraine. You have higher education. You graduated from the Dnipropetrovsk National University with a law degree. In 2001. Then previously you studied a degree in political science and teaching of humanities. You received a PhD in state administration in March of 2020. You claim 24 years of experience and work in the field of law, and I would describe you as a lawyer. You began your career working for a number of different law firms in late 1980s, early 2000, and you then served a brief term in the State Tax Administration of Ukraine. And then you began your work with a law firm that continued for a good number of years, originally Moore and Krosandovich, and more recently that firm apparently was renamed to Katernichuk, Moore and Partners. And then in 2018, you were given the opportunity and you became a member of the Central Election Commission of the city of Kyiv, and that continued for 2018 and 2019, and then you returned again to practice as a lawyer, head of administrative and election practices in the Katernichuk, Moore and Partner law firm. So that is a very, very brief summary of your work history and some individual details. As the chairman advised you, we give the opportunity to candidates to introduce themselves and their motivation for participation in the competition that our selection commission is conducting. So with that, I'm going to turn it over to you, Ms. Kustova. You have the chair and the floor, and we welcome your remarks.
Thank you, Your Honor. In addition to what has been mentioned by you, I need to tell you that I'm the merited lawyer of Ukraine. I'm also the tax inspector of the first rank. And since we are talking about reforms in the judiciary, it should be mentioned that I'm a compliance officer. So I'm a compliance officer as far as prevention of corruption is concerned. It should also be mentioned that in the 90s, I received a number of international grants from the US Congress. Those were grants for the interns of the Verkhovna Rada of Ukraine, and this gave me an opportunity to work with Hennady Golovenko, the 52nd President of the Assembly General of the UN, and also we worked together with the head of the Parliamentary Committee of the Verkhovna Rada, and after that I started my career protecting human rights as a human rights lawyer, actually. And because of Hennady Yosifovich, I got acquainted with Taras Chernovil, Levko Lukyanenko, prominent Ukrainian politicians, and it should be mentioned that these people changed my worldview because I came to Kyiv from eastern Ukraine, where the standards and views about the future of the Ukrainian state were. And these people taught me to love my motherland. And they taught me that my personal accomplishments, my individual progress were impossible without the progress of Ukraine. Serving my country is the best dignity that any lawyer, any judge can have. We are talking about the system protecting the rights and interests of people, the system of justice. So when we are talking about the judiciary reform, when we are talking about the reform of HQCJ, we should be talking about values first and about specific tasks that are at hand. As for me, the main task in the reform of the judiciary, even though I don't like the very word reform, is I like the word positive change, not reform, because it clearly specifies what we want to achieve. That is why the task of this positive change is to restore trust in the judiciary and to ensure that our people and stakeholders have access to justice. Behind me, my career shows you actually that I've been a human rights advocate for almost 25 years, and we've had a number of successful reforms in which I was involved. So I was looking for agents of change, trying to implement some reforms into the life of Ukraine. And twice I was able to contribute to the adoption of some laws. We completed reform on introduction of inclusive environment, reform of the electoral legislation, legislation ensuring the rights of IDPs, people with disabilities, introducing new principles and standards of elections. It should be mentioned, dear judge and all the other members of the commission, that if I have decided to apply for this selection, I will do my best to reach my goal. There are hundreds of lawyers that may be better than I am, who may be more talented or more professional. But many of those lawyers are on the front lines. Unfortunately, I cannot go and defend my motherland on the front line. That's why I decided to do it in a different way, to apply for this selection, because the judiciary and the judiciary reform is our weak spot. If we are unable to create this judicial front, I don't know whether our country will be able to bounce back after we win in this awful war. So that's basically all about my motivation. Now I'm ready to answer your questions.
Thank you, Ms. Kustova. We do have a number of questions for you, and I will begin. My colleague, Mr. Mischenko, will follow up, and then the rest of the commission members will also have questions for you. We obtain information, Ms. Kustova, from many sources, of course. Many of our supporters in this process, including NABU and NACP, civil society, etc. And one of the concerns that we must pay attention to under the law of Ukraine on the judges and status of judges is the issue of property and financial issues. And that is part of our integrity examination. So I will lead with questions in that area. One concern that arises when I reviewed the details of your financial situation, particularly income, there is raised some significant questions in my mind. In 2013, and I want to remind you that when you were working as a lawyer for the Moore and Krozandovich law firm in Kiev, you recorded income of $12,288. I'm sorry, hryvnia, 12,288 hryvnia. In 2014, the next year, when you were already working at the Karernechuk, Moore and Partner law firm, you reported income of 10,974 hryvnia. In 2015, 11,454 hryvnia. In 2016, 16,902 hryvnia. I am advised that that is a very, very low income to be derived from work as a lawyer, and you held the position as head of administrative and election practices with those law firms, or that law firm, and that for all intents and purposes, the level of income you declared was minimum wage. Although you had been a lawyer for many years by that time. How do you explain that? There are only two possible explanations that I can reach, or conclusions. One is that you did not declare some income, or alternatively, you didn't work very much. However, there may be other explanations, and that's my question.
First of all, my property status and my lifestyle do correspond to the income that I was getting. You should also have information about the income of my husband, which also complies with the level of income necessary to maintain a family. Since 2013, I've been dealing with cases solely on pro bono basis. That's one thing. And there is also the other thing. My child was really sick, and I tried to pay more attention to my child. My child had some problems with their back. That's why I was not so much involved in my professional activities. I was offering free of charge consultations. I defended people during the Revolution of Dignity. I was part of a team of lawyers who defended the students of the Karpenko-Kari Institute. And at the time I started working on my PhD thesis, I started working on draft laws. And these types of works do not always translate to income. So, unfortunately, there are not two options here, but three. Serving your people is not always rewarded with money. And I am thankful to my company because regardless of my social activism, they still employ me. And regardless of the pressure exerted on my company, I'm still working with them. I was involved in some interesting cases involving Mrs. Dombrovsky and Baloga. And those cases required a lot of effort because we were working under psychological pressure. That is why I would like to draw your attention to the following. Well, first of all, my family has had enough income. We do have enough income. You cannot earn all the money in the world. I'm not a judge. I'm a person who's been helping others for all her life. I'm helping those who don't have the means to pay should they need the services of a lawyer. That's why I think that the level of my income complies with my lifestyle. That is my answer. I don't think I have not committed any violations in this sphere. There was no evasion from declaration of my income.
The most that you earned was in 2019, where you earned 2.2 million hryvnia. I presume that is from your role as member of the Central Election Commission of Kiev. But then again, in 2020 and 2022, your income, again, was very, very modest. What explanation do you have?
Yes, Your Honor, because lawyers working pro bono do not make a lot of money in this country. That's one thing. And the second thing, Your Honor, is that I'm no longer actively involved as a lawyer because it's hard for me to work with current courts, and I try to be a lecturer. And lecturers in Ukraine have the average salary of 6,000 hryvnias. I cannot leave my students behind. My students are students with specific educational needs. If I could earn more, then I would probably work at other institutions. But I am supported by my husband, and I'm expressing my gratitude to him for that. Everybody has their own way. Mine is not to make as much money as possible. It's to help other people. I don't have a Mercedes. I don't travel to France, to ski resorts. I don't have many apartments. It's enough for me to have what I have. And I think that I'm leading a worthy life. And if civil society organizations or the NACP who make 2,100 hryvnias, if they believe that 6,000 hryvnias is a salary that is too low, that maybe we need to introduce reforms resulting in the increase of salary for professors of university. I have not committed any violations. I'm declaring all my income, you will see that my income is modest, and for that reason I took out loans at the banks. After my divorce, I had to take some business projects, so that's why my income has increased. And in my declaration, in my most recent declaration, my income is around 40,000 hryvnias per month. But thank you for the question.
Let me change the topic. Thank you for your answers. And I'm concerned with your political activity. Information that has been provided to our commission tells me that you have worked as an assistant to many members of parliament during many years. In 2002 to 2006, you worked as an assistant to a gentleman by the name of Mykola Hernachuk, 2006 and 2007. That continued. Then in 2007 to 2012, you worked for Roman Zvarchik, or Zvarch. Varchik, our Ukraine People's Self-Defense Bloc. In 2012 to 2014, you worked for Mr. Petro Poroshenko when he was a member of parliament for what looked like 3 years. And then in 2014 to 2019, you worked for Irina Friz. And in 2019, you worked for Rodislav Pavlenko. That would suggest, and all of these were for different members of parliament and for different political parties. So you appear to have a very keen interest in politics, and you have a very long and varied work history on a volunteer basis for members of parliament. You, in your declaration, have declared that you are no longer active politically, and you are not a member of any political party. However, your history would suggest to me that you have some very strong connections politically with politicians, including one that has expressed, if not declared, his candidacy for the presidency, Mr. Poroshenko. So what can you tell us about that, and why should we not be concerned that you may be under political influence if you are appointed to the High Qualification Commission of Judges?
Thank you for the question. So there are two aspects here, several aspects. So my former clients include Viktor Yushchenko, Yuri Kluchkovsky, Yuri Lutsenko, Mr. Poroshenko and Dombrovsky, and many, many others. I was assistant to many MPs, actually. But first of all, I'd like to tell you that all of them were worthy people and are worthy people. They are patriots without whom no change would be possible in this country. So I worked with them under civil agreements, civil law agreements, and I've never been a member of any political parties. I've never run for any political office. I didn't want to be a people's deputy. And there are some provisions in the Ukrainian legislation. So the issue of political impartiality is not a subjective assessment. There should be some criteria or categories to political neutrality. And according to the law on the Constitutional Court and an ACP, a person who lacks political impartiality is someone who is a member of a political party or who is trying to be elected, and it's also a person who supports this political party, shares their values or supports them financially. And I'm not a member of any of those categories. And according to Article 23 of the law of Ukraine on bar, we cannot in Ukraine identify lawyers with their clients. And those MPs that you've mentioned are patriots of Ukraine. Irina Fries set up the Ministry of Veterans. Rostislav Pavlenko is somebody that we've been together during different revolutions, and these people are not exerting any political pressure on me. And if I was interested in politics, I could become an MP, I could become member of the Verkhovna Rada, I could become a judge of the Supreme Court, but that's not what I'm interested in. I always implement the reforms that I believe to be beneficial for our society. For instance, I would not have been able to implement the reform for children with special educational needs if I didn't have these ties with Irina Fries, Irina Herashchenko, who are our members of the parliament. But as a result, we've had this reform. We have inclusive education, and I was able to achieve this result solely for the reason of me knowing these MPs. I'm not a person who lacks political neutrality. Nobody can influence me. And as you can see, I've never been a supporter of one single political party. I was guided by the needs of our people. So those were often the opposition parties, and somebody needed to help them. So to answer your question, both from the factual and legislative point of view, I don't meet the criteria of a person who has lack of political neutrality. And I hope that you can agree with me. It's okay to have friends in different circles, because we are all people, we are people of a specific profession, we do have some ties to others, but if we talk about political pressure, my friends cannot exert it upon me, and they will not be doing that. But thank you for your question. They could not even think of coming up to me and tell me about this political pressure. Your Honor, excuse me, but I've worked at the Central Elections Commission. It was an organization that everybody considered to be very biased, but we showed everybody that elections can be independent, impartial, and we received very high evaluation from all the independent experts, and I received gratitude from the head of ICAS, from USAID, and I believed it was the support of the people of the United States, and thanks a lot to them for that. So, to answer your question, nobody will able to exert pressure upon me. Thank you.
Yes, thank you for your answer. I've been provided with information that suggests that after your listing of the 64 candidates that we are now conducting interviews with, there were some negative comments made about you by De Jure Foundation. And I understand that that you have now threatened to sue de jure for those comments. And as you know, the civil society organizations are a participant in the judicial reform movement, and they often, along with other CSOs, express opinions with respect to certain candidates. And should you be elected or appointed to be a member of the HQCJ, you will have to have positive relations and cooperation with the CSOs. And I'm wondering how you intend to be able to do that if you threaten to sue them in court. And if I could have your answer, please.
Your Justice, Your Honor, thank you for the question. I hope I have not interrupted you. So here are 2 points. My experience of working in the state judicial administration and in the Central Election Commission shows that civil society organizations and expert environment, our insurance, our safeguard, and between like us, who should be independent, and this political pressure. So these are the safeguards against pressure. And I have good relationship with a lot of civil society organizations, Opora, the Committee of Constituents of Ukraine, of electors, of voters of Ukraine, the OSCE, some other civil society organizations that deal with election, the ones that dealt with protection of IDPs as far as their voting rights are concerned. And I was always promoting these ideas. You should know that I consider cooperation with civil society organization to be a safeguard for any loyal, independent body against any pressure. So I'm always positive about this sort of cooperation. That is the fact, and it doesn't even have to be proven because Opora, Chesno, and a lot of other organizations that have been cooperating with me have got positive feedback. Concerning de jure, I'm always responsible for what I say. And I think that over all these years, I have acquired a certain reputation. And my reputation is a very important thing for me. I think it's also important for you. And here on the internet, there appears some information that shows that in 2017, I acquired a car, which I bought in 2013, that I am a single mother, though back then I lived together with my husband. I have the minimum income, as they say, and it was not possible to live on that income, though back then I had a husband who earned quite a lot. That in 2020 I lived for a certain amount, but they do not mention the credit money and the savings I had back then. So is it okay to find this information, to put this information? They didn't answer my call. I wrote a letter, they did not respond. Then I found their founders and leaders on the Facebook page. None of them gave any response to me, but for Mr. Shemedin or something like this. And let me quote, Svitlana, I don't know you. If you have any problems, please find the person who has written this. I have found the people who have written this post. I wrote a letter to them and said, here is my email, here are all my declarations and all my explanations, the ones I have given to you, Your Honor. My phone number. I'm ready to cooperate with you. Let's have a meeting and I will tell everything. Do you know what the response was? No. Anyway, we think that you are an indecent candidate. You are not decent enough to be the member of the HQCJ, and our lawyers claim that this amount of money was the amount which you could not live, so you're hiding income. But if I am hiding income, why should I take a credit? So I warned them that let's have a meeting or I will sue you. And they said, okay, sue us. And so I sued them. I started suing them. And besides that, there are two applications to the prosecutor's office in Nabu because their information fully does not correspond to the information which I have in my judicial dossier. So they've got the information from my judicial dossier and they have disclosed the information because some of the data fully corresponds to what is in my declaration. After the selection procedure, I will address the respective bodies. I'm not doing this now. For this, my going to court not to become the grounds for the termination of the selection procedure until the case is concerned, because we have had stories like that. I want this competition, the selection, to happen, and after that, I will bring these people to account, because I want them just to make a public excuse. Because you see that this information has already developed even your perception of my personality, of my candidacy. And it's not that they are criticizing me, they are lying, and they have not been willing to contact me, to communicate with me. And you know, this collective responsibility in a way leads to the situation when nobody is responsible individually, but everybody should be individual for his or her deeds and words.
Thank you for your explanation. I am going to ask my...
I've always been working with civil society, and there has been no single case when I didn't want to cooperate with anybody. But if people are violating the law, breaching the law, they should be responsible, no matter whether we are talking about civil society organizations or state institutions or individuals.
Yes, thank you.
I provided the written explanations to you. I have provided my complaint, have submitted to you, and I think that you and the Secretariat will have a chance to assess how true it is.
Well, and that's why I asked the questions, to give you an opportunity, Ms. Kustova, to provide us with your explanation in person. So I will now ask my rapporteur colleague, Judge Mischenko, to ask you any questions that he may have.
Thank you. Пані Світлана,
Svitlana, so at the same time as we are having the competition, you have also submitted your candidacy to the High Council of Justice following the court under the court of the President of Ukraine. What is a priority for you, the High Council of Justice or the HQCJ? Ivan, well, probably I don't need to say this, but that's what is in my nature, to be open. And this competition is a priority for me, in the sense that here I have at least some opportunity, if you will pass a decision like this as a joint body, to become a member of the HQCJ. As far as the selection for the High Council of Justice is concerned, let me tell what motivated me to submit my documents there. In 2019, the Central Election Commission was actually stopped its activity, and it was done illegally. And then the president of Ukraine said that Mr. Stefanchuk just approached him and said that the commission should be changed. When my father saw this, he just died. He had a heart attack. I always wanted to ask the president the question, what was he guided by when he was actually breaking the faiths of in the lives of so many people who worked there? So for me, the competition for the High Council of Justice was kind of an opportunity to meet the president and to ask this question: how is he living now after he has made the lives of a lot of people collapse? That's why this competition is really important for me. I don't have any chances to become a candidate under the president's quota, in fact. But I want to face him and to ask him this question. Have you answered your question? Yes, more than enough. In your motivation letter, Svitlana, you keep stressing that there is a need for a drastic upgrading, updating of the judicial staff. Please comment upon this statement. Do you really think that we need to change all the judges?
Ні, я не вважаю, що треба змінити всіх суддів, ваша честь. Я вважаю, що необхідно, по-перше, докорінне зміни
I think that the judicial drastic changes in the judicial staff presuppose, first of all, the opportunity to have a competition, to have a selection, and to bring in new judges into the system. You have been working as a judge for many years, for 5 years. And in our courts, we have judges not just of different generations, but judges of different epochs. Their attitude to the trial participants could be different. They have different views, different approaches to the rights of trial participants. That's why we definitely need just to fill the system with new blood, fresh blood, and new people who are ready to change and themselves and to change the system. Besides that, we need to stop the activity of judges who keep violating the legislation, who are collaborating with the enemy. And we need to avoid the situations when then thousands of decisions or tens of decisions will have to be cancelled. But of course, the judiciary has great experts. This is, for example, Mrs. Grigorieva. She's a kind of a benchmark for me. The judge of the appellate court, Robman, is also a perfect judge, or Spichak in commercial court. But along with that, there are some judges who just ignore and have contempt for the trial participants, and I could also give names. There is no need for that. Thank you. Drastic changes, from my point of view, lie not that much in the changes in the judicial staff, but in the change of the ideology of judicial work. That is really important for me. And I think that this ideology lies in the fact that judges should ground their work on the concept of treating trial participants with respect. They shouldn't have any contempt for trial participants. They should keep with the ethics principles and with the rules for accessing justice. Because accessing justice doesn't mean just accessing justice. It means access to the premises of the court. Like when I stay in the court premises, it's hot, there are no chairs there, and judges are late. They are about 2 hours late. For example, I had this in Pivdene Appellate Court, I think like that, about 3 months ago. And a person who came to that court with me just felt bad. The new justice program or system presuppose not just the changes in such indicators as access to judges, the quality of judicial decisions, court administration, judicial independence. They also discussed the need for provision of access to justice as far as court premises are concerned, respect of judges for trial participants are concerned, respect of assistant judges for trial participants. So this is a comprehensive approach, and I think that if these comprehensive indicators are not applied, we will not revive the trust in the judiciary. Svitlana, sorry, I have to interrupt you. Just as a clarifying question, may I ask you the following? Staff shortage in the judiciary and insufficient funding of the judiciary, and in general,
відношення до тих приміщень, в яких
judges, unfortunately, don't have anything to do with the court premises. And judges would probably also be willing to get some new, more modern premises, but they cannot affect this process in any way possible. So maybe the problem is not about judges in this. Maybe we could demand something from judges, but at the same time, we should provide the judiciary with sufficient resources, which they lack, and then we could demand more. What do you think?
Ваша честь, я прокоментую це.
Let me comment it as follows.
В Швейцарії суддя розглядає
In Switzerland, court considers 20 cases a month, or rather 10. In France, 20 cases a month. With us, in Ukraine, we have judges who hear and pass decisions in 120 cases a month, and their decisions are quite good. I know such judges, and I know a lot about judicial workload. But if you go to the corridors of Pecharsky's court, you will not see any queue there, and judges actually don't have high workload there.
часу пізніше.
But they are 2 hours late for the court hearing.
Ніхто не заважає суддям
And judges do not follow procedural timeline, and they do not say, well, the claimant, are you sleeping? No, they should not address them in that way. Of course, they will not buy some chairs with their own money, but there are some other issues of compliance with the legislation, with judicial ethics and respect for all trial participants. Okay, clear. I know that. Oh, okay, sorry, I have heard your answer. Let's move on, and let me give the floor to my colleagues. Yevhen, Serhiy, Yevhen. Let me start. And good afternoon, Svitlana. I'm Yevhen Mezentsev, and let me continue our communication with you within this interview. Svitlana, we have got some information showing that just a moment. In 2015, you were the representative of Petro Poroshenko. What was your mandate within that position, and what kind of activity were you dealing with as a lawyer at that time? I was the representative of Petro Poroshenko in the Central Election Commission. Do you mean this? Yes, it was the representation of his interest in the Central Election Commission, and I think that this is clear what my mandate was, because the mandate is determined by the law on the election of the president of Ukraine and now the election code, to bring in the documents, to bring the documents for the registration of Mr. Poroshenko, his representatives, members of local election commissions on his behalf. Yes, but if we take this period of election to the presidential office, I know that you were actively promoting this election, in particular representing the interests of the future president. Yes, I represented his interests, who was the candidate for the president. Yes. And that was the same as I did for Mr. Yushchenko. And this does not show anything about our political engagement, my political engagement. Yes, but we have to talk about this. You know, we have been talking for 47 minutes whether I'm the representative of Poroshenko, whether I have stolen any money from the state. But we're not talking about my vision of the reform of the judiciary in the High Qualifications Commission, in spite of the fact that I have great background. Yes, I have represented Poroshenko and a lot of other politicians, Yushchenko, Tymoshenko, and that was not because I'm politically engaged, but that's because I'm one of the best, and nobody will argue here that I'm one of the best representatives in the field of election law. And I represented them all the time because I wanted to work in the Central Election Commission. But the Central Election Commission doesn't have any selection. If you're not a member of the party, if you're not a relative of someone or a proponent of any political figure, you will never get to the Central Election Commission. And the work in the Central Election Commission has always been my dream, because this is about people, about changes, about real fulfillment of democratic requirements in the nearest days, weeks, and months. And I always knew how to do this, and I really wanted to represent the interest to one day become a member of the Central Election Commission. You claim that I have some contacts with Mr. Poroshenko. I don't. No, I have not mentioned this. I'm sorry. I have not been working with him. I never worked for him as in his administration, in his companies. I didn't work in the administration of Yushchenko. I've got my own views, and if a person is an oppositionary, you need to come and to provide qualified assistance to him, in particular in the Central Election Commission. You know what kind of year 2014 was. You know what events happened there and what kind of cases we had. And I'm proud of representing him the same as I'm proud of representing Mr. Yushchenko. Okay, Svitlana, could we go over to some other issue? Yes, it would be good, Your Honor. Do you think that raising the level of trust in the judiciary would mean reinforcement of the role of the state executive service, enforcement service, and will improve the system of decision enforcement? It's a comprehensive issue, Your Honor. Let's consider it through the prism of our mandate and then those of enforcement service. I've made a comprehensive analysis upon the request of the Council of Europe and IFX. And the analysis was aimed at what we could do to improve justice administration and enforcement of judicial decisions. We need to influence the moratorium. We also need to introduce the system of one right, one procedure, for people not to address some other court instances after that. We need to have the proportionality in the issue of charge imposition, because we had some cases when a person had to pay 1,000 of alimony, but the fine for non-payment was about 1 million. So there are a lot of things that have to be changed. So I think that these issues could be generalized, and I have a certain scientific paper dedicated to those issues, and I've visited a lot of international forums dedicated to those issues, and the head of this, the chairperson of the Supreme Court, participated in them, so we communicated on those materials with her. And I could provide my materials to the National School of Judges and generally we could work towards the improvement of enforcement of court decisions. I cannot affect the enforcement service, but of course all the lawyers who are practicing lawyers know that this enforcement service has some problems. And I hope that introduction of good mechanisms to fight corruption will also improve the service and the mechanism of timely enforcement of decisions. But we do have enforcement service, no? Yes, we have it. That's what I'm saying. That all really affects enforcement of court decisions. If we speak about drawbacks of the enforcement service, everybody knows about them. But from the point of view of legislative moratoriums that you have concerning compulsory enforcement of decisions, in particular the moratorium for imposing charges on state-owned companies, is it justified? No. And if we cancel them, will it not lead to better results of the state enforcement service work? These moratorium are not effective. Everything is fine, right? I'm sorry. The moratorium is no longer effective. That's why we should cancel the moratorium. I think that we have about 10 moratorium, 10 bans. And of course, this has a negative effect on the issue of social benefits and creditors' requirements. And when I studied this practice, I saw that some courts have passed decisions to
щодо обов'язкового виконання рішень наших
decisions on obligatory enforcement of decisions, even in case there is a moratorium on the basis of Article 129. And I think that the Supreme Court was going to address the Constitutional Court to somehow deal with those moratoria. I think that the moratoria should be cancelled. Besides that, you remember the introduction of the moratorium on the Treasury for deducing the money from writing the money off the accounts under court decisions, and then the Constitutional Court also canceled this moratorium. So I think moratorium is a very harmful thing to do. It has a detrimental effect, and this is a negative practice in the protection of rights of citizens and legal entities who are creditors, or which are creditors of those companies. Well, at least this money needs to be written off, but the accounts. But we need to address the Verkhovna Rada for it to revise the regulatory expediency of those moratorium. And some judges pass decisions on the basis of their constitutional norms of direct effect. We do have this practice, and it's also present in the Supreme Court. If we take into account the current situation in Ukraine, don't you think that it would be efficient to introduce remote assessment and remote selection procedures for judicial candidates and incumbent judges? Including, well, by mentioning remote, I mean Zoom and other things. Yes, I'm a lecturer, so I know what you're talking about. Well, no. I think that it's still necessary to introduce face-to-face selection procedures because, well, you will never understand a person the way you can understand what he or she is like while communicating face-to-face. Because I'm staying with you now, and I can see that I cannot change your perception of me that has already been shaped up. And the algorithms of behavior are different if we are staying in Zoom or online. If we didn't have the screen dividing us, I would probably be telling different things and behaving in a different way. And the people doing the selection need to see a person, to ask questions, and to always bear it in mind that we need not just to listen, but to hear what the person says, to lend an attentive ear to that. And sometimes there is a great difference between what a person meant to say and what a person really said. And only personal face-to-face communication allows us to make an objective conclusion as to whether this person is capable of settling any issues related to integrity and other issues. So I think that we need to have face-to-face selection, face-to-face trainings. Clear, thank you. Your concept, and I think that schools are getting back to offline studies, so why shouldn't we? And by the way, I'm addressing the Selection Commission with the request for a face-to-face interview. If you could restore this process. Okay, thank you. Let me give the floor to other commissioners. Ivan, Serhiy. Well, sorry, sometimes I get too much carried away. No, it's, and that's why I called you Ivan and not Yevhen. No, we are pretty much the same. No problem about that. Svitlana, my name is Serhiy Verlano. Let me continue with this interview. In your motivation letter, you mentioned that you are well aware of the best global practices of fighting corruption. You have gone through the training, and you've got the status of the anti-corruption compliance officer. Yes, that's true. And where are you applying the knowledge you have acquired, you have gained? I'll give the examples. I help companies. I provide consultations to companies concerning ISO 37001, and I provide consultations to MPs concerning corruption risks available in some draft laws. For example, if we take the law on the judiciary status of judges, I can tell you that compliance, as a compliance officer, about the corruption risks available in Article 19 that presupposes assessment of judicial knowledge. I think that this article needs to be changed because it contains a lot of corruption risks. I would like to say, Your Honor, that were it not for the introduction of the active anti-corruption policy by the NACP and NABU, I would probably not be participating in the selection procedure, even if we don't take into account my motivation. If we speak about corruption practices, well, I think that we will need to introduce qualification assessment of judges on a regular basis, and there should be also qualification assessment of investigators, of attorneys, or the so-called bar exam for lawyers, for attorneys at law on a regular basis, let's say every 3 years. And we should have qualification assessment of drivers, for example, because people are sometimes dealing with self-education with no requirements set for this. And we are attorneys at law. We are the source of higher danger because people depend on us. If we don't read something properly, we would be responsible for the decisions passed. So I think that we need to introduce independent qualification assessment of judges at least once in 3 years. And of course, this should be done with due account of specialization, institutionalization, and so on and so forth. But this is going to be better than just the subjective assessment of the lecturers of the National School of Judges that would be then set out in the documents in the judicial dossier. And here is one more important thing, Your Honor. It just seems to me that it is important. When I decided to participate in this selection, I started preparing because I always prepare for different projects. So I thought over my steps, my first steps in the HQCJ for the first week, the second and the third week. So first of all, I would get acquainted with the ACP's strategy for fighting corruption. Unfortunately, the HQCJ is not involved in the anti-corruption practices development, and it should have been involved in the development of the strategy in terms of giving some feedback. Well, thank you for your suggestion, and let me give the floor to Judge Markman. Stephen, you're welcome.
Thank you, Judge. And thank you, Ms. Kustova. We appreciate your participation in this competition. I would just preface my statements by saying that we know these questions are difficult, but we ask them so they won't be considered silently, so that you have a chance to help us understand what the truth is. That's all. We're obligated to have a high qualification commission that's trusted by the people of Ukraine, and that's the only reason we ask these questions. We have no unalterable views of you or anyone else. You're responding as you see appropriate. We thank you for that. Let me move in a different direction at this point. I think you have an incredible background here. You've been a member of a variety of important commissions. You've drafted laws. You've prepared reports. You've had work with major political figures, national and international. You've been an expert. You've been on the Council of Europe. So you do have an incredible record. It seems to me it's focused more on election issues than on judiciary issues, perhaps. But I ask you, what have you learned from all this? What is the lessons that you've taken away? For 20 years, you've had a tremendous involvement in civic activities in your country. What have you learned from all this, and how do you think it would help you serve on the High Qualification Commission? Again, with the understanding that your emphasis has been, I believe, unless I'm wrong, it's been on election matters and not necessarily judiciary matters. I'm not saying that wouldn't be helpful on the commission too, but help us understand what you have to contribute to the commission. How would you serve on it and serve well and help your country and help the work of the commission?
Ваша честь, дякую за запитання.
Your Honor, thank you for this question.
Відповім на нього таким чином.
And my answer will be as following. First of all, I see my activities as a person who was always supporting the good side. Do you know Judge of the Federal Court of the U.S., Judge Futi? On many occasions, has been to Ukraine.
I'm sorry, Judge Poutet?
Futi, Bogdan Futi.
Bohdan Poutet. Yes, I know him very well. He's a friend, longtime friend.
Верховенство права – це є головним, да, я його також добре знаю. і ми дуже
Yes,
багато
he is a good friend of mine, and we've talked to him on many occasions.
розвитку не запобіжниками, умовами розвитку
So we discussed the conditions for the development of a country. Yes, elections
захисту прав людини.
are an area of my interest, but I'm also interested in the protection of human rights, gender equality, the protection of children with disabilities. That is why my income is low. You told me that my income is low because you're not paid well, if these are your interests.
Я отримала колосальні гроші.
So over the duration of my career, I've gotten this immense experience in communication strategies, in selection procedures, because the Elections Commission was responsible for the selection and training of members of the smaller election commissions.
Місяць я проводила
Over
приблизно 630
1 month, we've conducted around 630 trainings for members of the commissions.
При цьому я
We have 225 circuit commissions, so you can imagine the workload, and we were selecting candidates to different types of commissions. I do have this vast experience of working with people. That is why I have this understanding where I'm applying. So it's the most important thing, what your motivation is and your realization, what is expected of you. I understand that we will be working under psychological pressure. In stressful conditions, we will be working 24/7. I will be working with people who may dislike me. So I will have to find ways to communicate with them, because we all need to work to achieve the result. What kind of result? In my opinion, in the short-term perspective, we need to introduce improvements of access for justice. This is what I see as the task of HQCJ, access to justice, number one. Number two, decrease the workload of judges. Number three, introduction of anti-corruption strategies. I've talked to an ACP. I'm a person who, if involved in something, tries to get to the bottom of things. So there's this idea about annual monitoring of the lifestyle of judges as a preventive mechanism, as an anti-corruption mechanism. So we need to ask ourselves specific questions. We need to talk about specific indicators: access to justice, decrease of workload, and introduction of anti-corruption strategies. And after a year, we will have to review our work to see whether we've met the indicators. I've watched a number of interviews, and on many occasions you've asked about restoration of trust in the judiciary.
That's point number one. Priority
So
number one.
one of the interviewees cited Hamilton, as far as I remember. And I was told by an acquaintance of mine who said that any government is interested in a weak judiciary. And he also cited Hamilton, because judiciary is effective only if supported by people, if trusted by people. In 2019, Zelensky tried to disband the newly created Supreme Court. And it was the trust of the people that allowed for the court to survive and to have the decision of the Constitutional Court of Ukraine in its favor. And it was the trust of the public that helped.
Can I interrupt you for a second, because I'm going to lose my chance to ask you a few questions very soon. Do you mind if I interrupt with a couple questions? Because you've got a very fine motivation, I think. You've got a fine background.
Yes, definitely.
But there's some terms I don't quite understand. If you can give me just a little bit of guidance. You talk about human-centered justice several times. What does that mean? Isn't all justice human-centered? What does that mean to you? What's the importance of that term? I don't understand it. Please.
Ваша честь, в центрі правосуддя має бути
Yes, I'm talking about human-centered justice, and it should be obvious, but our justice does not always have an individual at its center. And sometimes when we appear before the judges, we see that some of them are either under alcoholic influence or they don't know who the parties are. The decisions are not always enforced. So our justice does not have a human at its center. Some judges are offensive with regards to parties. At Pechersky Court, a person with my type of experience, it took me a year to submit a claim with that court. Does it mean respect for people? No. I think judges should comply with the procedural terms. They should know how to write proper judgments and decisions. They need to use efficient ways of restoring violated rights. For instance, a decision may be made to cancel some kind of articles of association of a limited liability company. We are talking about aspects of substantive law, and we need to regain this trust in the process. I can invite you to the Pechersky Court of the city of Kyiv, and you will understand it for yourself. What the problems with the judiciary are.
I want to move on here. You talk about gender equality. Is that the same thing as gender quotas, or is there some more flexible understanding to what you mean by gender equality? Are you talking about quotas, or are you talking about just giving fair consideration to people of both genders?
Ваша честь, я буду, може, не популярна.
Your Honor, my decision may not be very popular, but
We prefer honesty to popularity.
Я зрозумію, я вам об'ясню. От, ваша честь, давайте подивимося на мене.
okay, look at me. I'm a woman. I'm a divorced woman. I have a lot of work. I have a small child. My mother is sick, and I need to get ready for my work. I need to participate in trainings. I need to search for clients. Please tell me, who has more opportunities? A man who is free of all the household chores, who doesn't need to take care of the children, or a woman who has all these chores and needs to have a career? Yes.
No, I'm not trying to argue. I just want your understanding. Okay. Okay, let me ask you one more, and then I'll leave it to my colleague here. You talk about zero tolerance for corruption. You talk about zero tolerance corruption. When I think about that, I think about what we have in the United States, which is called the broken windows rule, which means that the police don't focus only on large offenses like burglary and arson, but they also focus on lesser offenses, because people who commit those lesser offenses will soon, it's believed, commit greater offenses. So tell me what you mean by the zero tolerance for corruption theory. Does that mean that any declaration, however variable from the truthful declaration, is subject to some kind of accountability, or what does it practically mean to you? You know, what does zero tolerance for corruption practically mean to you? Because I assume you would apply this standard on the high qualifications
Я
commission.
своїм студентам
Yes, thank you for the question. I've understood it.
приклади на суді.
So I like to provide examples from my own life when teaching my students. And when I was working for the tax authorities, I was able to change the ideology of the state tax authority, but once we had this case when some VAT refund was expected of me, and I was given a document that I needed to sign. So I went to my manager, I went to the minister, and then I resigned. And please ask your colleagues how many people resign from the state tax service. Zero tolerance for corruption is not about tax declarations. Yes, I've myself made mistakes in my tax declaration. Yes, I was able to identify them and I reported about them, but it's a human error. But if a person's wealth and their assets don't meet their lifestyle, if there are these factors that tell us that a person is having some illicit wealth or illicit income, then this is corruption in its fundamental sense, because any mistake is not corruption. I'm a very straightforward person. I am tolerant but straightforward.
Okay.
I've never wanted to be part of the judiciary, because within the judiciary there are only few people who meet the requirements for zero tolerance policy. Yes, maybe you don't take bribes, but you know who of your colleagues takes bribes. Maybe you're not corrupt yourself, but you see your colleague who drives a Range Rover. Maybe you are not corrupt, but you see people interfering with the distribution of cases. So these people are just silent witnesses. Nobody is reporting about these cases of corruption.
Ms. Kustova, I'm going to have to move on. You've spoken with a lot. Ms. Kustova, I'm going to have to move on right now. You've spoken with a lot of passion, and let me ask my colleague, Mr. Brookhuizen, if he wants to pursue my questions or go in a different direction, okay? Thank you again.
Mr. Chairman,
Thank you.
I have no question.
Когось назвати колегою.
Thank you. Thank you, colleague.
Any further questions, colleagues? No? Пані Світлано, наша співбесіда
Svitlana, your interview is coming to an end.
підсумуйте її, будь ласка.
Could you please summarize everything that you've told us today? Is there anything of importance that you'd like to tell us towards the end? Suppose
Будь ласка, вам слово.
you didn't have the opportunity to express that idea.
Хотів би перше сказати,
Thank you, Your Honor. So,
мою точку зору, мій погляд на
first of all, I want to tell you about my opinion on the work of this selection commission.
філософію створення зіркових
So,
команд чи команди зіркових.
it's up to you whether you want to have a team of celebrities or a team made of individuals who will reach a result.
Роботи в Центральній виборчій комісії.
Before I started working at the Central Elections Commission, I met with the future members of the commission and we developed a plan of action for the first, second, and third week. So I have this clear understanding of what we will have to do during week one. So during the first week, we will have to update the information. We will have to work within the anti-corruption program. We will have to address the parliament because the Parliament has already adopted during the first reading a draft law on the shortening of training in the National School of Judges. We need to discuss things related to technical support. We need to do due diligence of the documents. Information and security aspects are also of importance. I know what I have to do. I know how I will be doing it. I'm not sure that I will be appointed, but maybe candidates will need my support, even if I'm not part of the 32 candidates selected or the 16 candidates selected. I will be eager to meet any of them, to share my knowledge, to help them in their work, in their mission, to make it easier. Because I understand and realize how difficult it's going to be. I'm aware of the potential political pressure on the part of civil society. So I wish everyone to win, not to win in the sense that you were selected, but to win by being successful in the judiciary reform, regardless of whether I will be involved in that or no. Thank you. Thank you for the opportunity to participate in this selection. Thank you, Svitlana. This is the end of your interview. Best of luck to you. Take care and goodbye. Goodbye. Thank you.